to do both hands. So, most everybody here probably knows who I am, but my name is Don Scholes, and I am the general counsel for the Tennessee Association of Utility Districts. And I'm intimately involved every year with the TAUD legislative effort. And so really for several years now, I have come to this conference for sure, and sometimes to a couple more, to try to give an update of what the legislature has done this last year as it affects utilities, local governments, cities, counties, utility districts. You know, all of you all that operate a utility, whether you are a utility district, whether you're a city system, whether you're a county system, how you operate is subject to what the legislature says as to how you operate. So what the legislature does every year winds up being important. Some years, important things happen. Some years, not quite so, but there's always something that happens that you need to know about. And this year was, no different. We have had some years that were more bills. We did have one bill that was important that I'm going to sort of talk through a little bit about really what that process was. Everything gets more complicated, and the legislative process in Tennessee has gotten more complicated. For many years now, TAUD actually has two lobbyists that work with the legislature, and they're a vital part of what we do. And so it's an effort that sort of involves the TAUD Legislative Committee, our lobbyists, and really you all as well. So here we go again. If you all have been following sort of what TAUD does with legislation, especially if you get the Legislative Express, you may have heard the term caption bill. How many people have either read that or heard that somewhere? Okay. So what's a I'm going to talk about what a caption bill is, because that one almost came up this year and almost bit us bad because of the way it processed. Okay, so what's a caption bill? I'm a lawyer, so I have to talk about legal things. So you just have to bear with me, okay? So there is a section of the Tennessee Constitution that states, "No bill shall become a law which embraces more than one subject. That subject has to be expressed in its title." So what that means is the way that a bill is filed and introduced by the legislators that sponsor it is important, because if that bill in fact becomes a law, it has to meet this test, which means that the bill can only embrace one subject, and that subject has to be expressed in the title. Now, there's a lot of liberty sometimes that's taken with that, but it's not uncommon to try to challenge a law that's passed on this basis, because it's an easy basis to do, because it's a provision in the Tennessee Constitution. So this is what a run-of-the-mill caption bill looks like. Oops. Let's see. Okay. So the bill has the name of the sponsors at the top. And this bill, the caption or the title of the bill says, "An act to amend Tennessee Co-annotated Title V, Title VI, Title VII, Title 65, and Title 68 relative to government approval. Those of us that follow legislation, that screams caption bill to us. Why? Because it opens up a number of titles, probably easier to think of as chapters in the code, and look at the description of the subject relative to government approval. Does that sound very broad to you? You should be shaking your head. Yes, that sounds very broad to me. So if you get our Legislative Express, sometimes you'll see these in the Legislative Express. But, you know, the actual language of this bill, you can't tell what it means because the guts of the bill is Tennessee Code Annotated Section 7-59-314 is amended by deleting subsection A. There's no way in God's green earth you know what that bill means unless you go back and look and see what is this TCA section that they are deleting. So this is what this bill did. It in its initial form. It amended a statute that was part of something called the Competitive Cable and Video Services Act of 2008. And it deleted a requirement that the Tennessee Public Utilities Commission issue a report by 2011 on state-issued certificates of authority for cable or video service. So this bill, as written, is saying that you have to delete a provision of the code that required a report by 2011. Everybody's antenna should be going up. This bill was introduced for a reason other than its stated purpose. So I'm going to go back to the first slide. This thing doesn't work unless I'm pointing it. So how do we, as TAUD, know we need to keep up with something like this? Honestly, sometimes it's a bit of a guesswork. So in this one, there were 2 or 3 things that made us say, we need to keep track of this. The first one is Title 5 deals with counties. Title 6 deals with cities. Title 7 deals with municipal issues and utility districts. Title 65 deals with public utilities regulated by TPUC. Title 68 is the chapter that has all of the TDEC authority and statutes. So that in and of itself is like, okay, we may need to watch this one. And when you look at the statute that's being amended, it's dealing with the Tennessee Public Utilities Commission. So that was enough, at least to put it on our radar. So a lot of those bills just stay on our radar until there's an amendment that comes up. Go back again, sorry. So, the legislative process is that bills are introduced, and the next thing that happens with that bill is it is assigned to a committee for review by the committee. Most of the work of supporting or objecting to a bill occurs before the legislative committees. Because if the bill goes out of a legislative committee with an approval or recommendation or its passage, you have just about lost your ability to do anything with that bill. So on a late Thursday afternoon, I happened to become aware of the first amendment to this bill. And that's what the amendment says. It basically says that notwithstanding any provision of law to the contrary, A unit of local government shall not make or require permit applicants to make improvements to any water or public sewer system without just compensation. So if you read that, would that raise a red flag in your head? It should raise a red flag. So again, had nothing to do with the original bill that dealt with the certificates of cable before the TPUG. So instantly, all of a sudden, you find out the real purpose of why this bill was introduced. Sometimes the bill's not introduced with a purpose in mind, but sometimes it's introduced as a placeholder so that if I, Mr. or Ms. Legislator, wants to change something, I have this broad caption that opens up 5 major titles. And what's the subject? Governmental approval. Okay. So this bill was amended, and the committee that it was going to go to was meeting. This was a late Thursday afternoon. They were meeting the following Tuesday. This amendment presented a real problem because the sponsor of this bill was the Speaker of the House, a very powerful person. And so that was one strike against moving it. So all bills that go before the legislature, before they go to the committee, there's a requirement that the Fiscal Review Committee of the legislature make an assessment as to what's the fiscal cost of this bill going to be on local or state revenues or expenses. Fortunately, TAUD through the years has developed a relationship with the Fiscal Review Committee. And if there's a bill that deals with water or sewer, it gets sent to TAUD, and it's usually to me. So that's how I found out about this bill. And I immediately started communicating with our lobbyists. Have you seen this bill? Did you know this bill was going to happen? Nobody had seen it. So it's now set for the following Tuesday to be looked at and potentially approved by the House Business and Utilities Subcommittee. Not a good situation to be in with a bill that has this kind of language. So immediately, first stop is the lobbyist. They had never heard of it. You see the language. It's bad, but nobody really understands what it means, okay, because of the way that it's worded. So, we sort of immediately had to go through a process of, one, trying to slow the thing down. Because if it gets to the subcommittee the following Tuesday and it gets, approved, it becomes more and more difficult to stop it. So anyway, there was actually an email that some of you all may have remembered that went out to say, this bill has been amended. We really need you to contact, your representative to say you have concerns about this bill. Always, as Ross made reference to, having a relationship with your legislator, this is the time when that comes in handy. And fortunately, those efforts were successful enough for the sponsor of the bill, the Speaker of the House, to sort of say, all right, we will move that. We will not consider this Tuesday. We will bump it to a week later. So after that, there was a week in which to try to come up with what is where did this bill come from? Who's really pushing this bill, and what can we do about it? So really over about the next week or so, first, our lobbyist had to take a lot of heat with the Speaker's office for stopping this moving forward, which they didn't like, but which they gladly did. So ultimately, what occurred was finally got to the point of understanding, yes, this was a bill that was introduced, at the request of a large construction firm, who had a close relationship with the speaker. So the bill was amended. TAUD and a couple other people had the opportunity to try to comment on the bill and to make some changes. And really, what ultimately learned was the issue that was involved with this particular contractor / developer really dealt with a requirement of a water utility that was requiring off-site improvements for service to the property. And it was also a scenario where there was already a water line adjacent to the property being developed. But in this particular instance, the water utility was going to require the developer to extend that water line past sort of where the existing line was, but still on this developer's property, sort of meaning that the offsite improvement wasn't really needed to serve the development. It was something that the utility was requiring that they do to give their approval. So trying to get to the point to where, all right, the real issue here is cost of offsite improvements. So I'm going to go through the bill as it ultimately got adopted, and hopefully it will make sense. Since the bill's passed, sky hasn't fallen. I've not heard of anyone that's had a problem with the bill as it was written. Doesn't mean that you may not have, may not in the future, but here goes. So this bill deals with a particular situation. And that particular situation is owner of the real property is requesting water service or natural gas service for a residential or commercial development on that piece of property. The utility has an existing line immediately adjacent to the property. So if the issue you're dealing with is a water line extension that's needed to get service to the new development, this statute doesn't apply. Okay. Only applies when there is an existing utility line immediately adjacent to the property and offsite improvements are needed. So this bill I'm going to describe, it's got to meet all four of those criteria for this bill to really come into play for you all. So if you meet those four conditions, then you can still require that the owner construct or pay for offsite improvements that are needed to provide the utility service requested or to maintain the utility's current level of service and capacity to serve existing customers. This was a concept that had to be explained to the person that was pushing the bill, that, what you're requiring may very well be dependent on what you're asking for. If you're asking for a water demand of a certain amount, that may influence what offsite improvements are needed. In addition, that, we don't want to impose cost upon our existing customers that are caused by your development that's going to require an offsite improvement. So the offsite improvements can still be required if it's necessary to sort of maintain the current level of service to your existing customers. So that's a must. In that scenario, the developer or the property owner, you can require the offsite improvements that are needed for them to serve the demand, whether it's water or sewer demand, and to maintain service to your existing customers. So the utility may require the owner to upgrade offsite improvements to increase capacity for future customers, especially those of you all that are in high growth areas. Most of you are probably dealt with the scenario where you partner with the developer to either increase the size of a line or whatever it may be to not only provide service to their development, but also to help you in future service to the area. So you can require that if there's improvements that you can make the developer do that's going to serve your future customers, you can do that, but it does have to be in a cost sharing arrangement. I suspect there are some instances where the utility that's had the position of power has sort of said, no, you'll do this regardless. Okay. So this is a change. It is going to require that there be a cost sharing arrangement. Now, because then the second may here is that this decision to require an upgrade or to agree to a cost sharing arrangement must be done within 60 days of the owner's request for a building permit. Those of us in here and me was like, what? Remember, this was in a metropolitan area, and it was the governmental planning agency that said, we're not going to issue a building permit until you agree to construct the offsite improvements. For most of the utilities, and I'm not going to say all, generally, when you're dealing with a new development, this building permit occurs way on down the road. I mean, you're talking to the developer at the very beginning about the water and the sewer improvements. But this was vital to the person that was pushing the bill. So it had to stay in there. I really don't think that'll be a problem because it generally occurs so late in the process. So again, if you can require an offsite improvement when making the developer participate in that, if it's for the benefit of future customers, pursuant to a cost sharing arrangement. So if the utility owner cannot agree upon a cost sharing arrangement, then the owner can request TBOR to determine an appropriate cost sharing arrangement. This was a great alternative that existed because of the change in the TBOR jurisdiction last year. People are becoming used to using the TBOR for utility issues. So got to have a cost sharing arrangement, but if you can't come to an agreement, then there's the ability of the property owner, the developer, to go to the TBOR to say, we can't reach an agreement on a cost sharing arrangement, or what they're requiring, I don't think it's fair and reasonable. So another new power was given to the TBOR as a result of this bill. So my hope is that this bill as written pretty much incorporates what most people do, but I have no idea how it's going to try to be used by property owners and developers moving forward. It could be a major issue at some point, or you might never hear from it again. It just sort of depends on what happens. So, but took a little time to go through this to just sort of, it's an illustration of the process and how we have to be very diligent in bills that are passed and introduced, because sometimes bills are introduced and there's an ulterior motive behind that bill, but you don't know it till the last minute. And so unfortunately, that's why you have to have lobbyists when you deal with legislation these days, even on the state level. And even with that, we almost got caught off guard with this one. So I'm going to try to do sort of a quick rundown of some other things that happened. So it is very rare these days that there's not some change in the law related to the Open Meetings Act, or what we like to call the Sunshine Law, and or public records. So this year was no different. A couple of changes to the Sunshine Law that dealt with public meetings. So currently, if a governing body of a governmental entity takes action and fails to abide by the notice provisions and allowing members of the public to be present, that action becomes void under the Sunshine Law. But historically, the person that is challenging the governmental action based upon a Sunshine Law violation has been responsible for their own litigation costs, including their attorney's fees. So this year, there was a new provision that was put in the Sunshine Law that basically says that if the court finds that there was a violation of the Sunshine Law and the court finds that that violation is willful, then the court has the discretion to award to the prevailing party, the one that's filed the lawsuit, all the litigation costs, including the attorney's fees. Okay, for good or bad, everybody knows sometimes that's the biggest cost in a lawsuit is the attorney fees. So this is a new provision for you all that may have probably heard of it. There is in the comptroller's office an open records council that mostly answers questions about public record request, but they also have the ability to give information related to the Sunshine Law. And so if you're in a scenario where this is brewing, contacting the Office of Open Records Counsel and getting their assistance in what your obligations are might very well be enough to prevent a finding of willfulness, because it requires a finding of willfulness for the reimbursement of the litigation costs and the attorney fees against the governmental entity to occur. So this sort of, for a couple, 3 or 4 years ago, there was something similar that was done with public records, meaning that if there's been a violation of the public records laws, somebody files a lawsuit. If the violation is willful, then the court could award the litigation costs, including attorney's fees, against the government entity that violated the Public Records Act. So this sort of brings this into conformity with the way public records lawsuits are handled. And while the term willful is used, there have been a few cases that deal with the willful requirement in public records cases. And that willful requirement is not a bad faith standard. They have found willfulness when everyone understood the obligation existed. So you don't have to show bad faith, but if you can show that the governmental entity was aware and knew that they had the obligation to provide public records, courts have found that to be willful. That same standard is going to be applied to one of these lawsuits. So going to be very hard for any public body to not claim that they didn't understand that they have to have public meetings. Okay. So this one is probably going to be used in the future. I had one on that. This bill also had a provision in that said a meeting, public meeting for sunshine law purposes doesn't include the on-site inspection of a project or program. Honestly, that's the way it existed anyway. So I don't think that was much of a change. This one's really interesting. Okay. So this bill, which was separate in Public Chapter 818, says a public meeting does not include a meeting of one or more members of the county commission or the city governing body with one or more members of the legislature representing the county or the city, provided the meeting was for the exchange of information and not deliberative in nature. Now, quick refresher, sunshine law. A public meeting occurs when the governing body is meeting and they either vote or deliberate toward a vote on business. It is not a sunshine law violation for the public body to have a meeting that is informational only. It's either making a decision or turning to each other and the governing body members and start talking about what you're going to do. As long as you're not deliberating, it's not a public meeting. So this doesn't really change the existing law in Tennessee, but it does put it down in statute. The other one is a member or members. So again, we're talking about a meeting where there's a state legislator or more than one meeting with one or more governing body members of the county commission or the city legislative body, and the member or members of the legislature conduct meeting to discuss state matters. That's a pretty, honestly, I think that's a pretty broad exemption. If your issue that you're dealing with is one in which the state is deciding where a new highway is going, whether you're going to get some kind of permit, well, if you can get a state legislator there and you're discussing state matters, which could be a very broad thing, that meeting can be held outside of the public's. No notice requirement. Public doesn't have to attend. Does that sound like a very broad exception to you? The answer to that should be yes, because if I'm the public entity and I've got a sensitive subject and I can make it, this seems devious, but if I can basically get a state legislator there and make an argument that it's a state matter, that can be a closed meeting. Okay. So pretty big change. It seems like every year some minor changes are made to the Tennessee 811 Act, Underground Damage Prevention Act, if it's its official name. So just going to talk about some changes that the Public Chapter 628 made. As you know, when there is an emergency locate request, the underground utility is supposed to get out there within 2 hours to try to locate the line. However, historically, the act didn't define emergency. It used the term emergency, but it never defined what an emergency was. So this year, an emergency has been defined to mean a sudden or unforeseen occurrence when there's clear and imminent danger to life, health, or property, interruption of utility services that requires repair or restoration, or repairs to transportation facilities requiring immediate action. So again, doesn't change the notice and locate requirements for an emergency. It just actually defines what an emergency is. There was a concept in the Tennessee 811 law, and it used the term impending emergency. No, pending emergency. And the impending emergency sort of provided that, well, if it was an impending emergency, then you didn't have to locate within 2 hours, but you did have to locate somewhere between 2 hours and the 72-hour normal time to locate. So this bill just sort of removed this pending emergency language. But at the same time, it basically just sort of says that gave the excavator that's calling in, for the locate to Tennessee 811, that they can let the utility know that they're not required to get out there in 2 hours, but, can specify anywhere between 2 hours and the 72 hours normal as to when they're going to need to locate. So eliminating this nebulous impending emergency, but allows the locator to let Tennessee 811 notify the utilities. You don't have to be out there in 2 hours or less, can give them a time frame between 2 hours and 72 hours to go out there and do the locating. Historically, and now it's 8 or 9 years ago, the 811 Act was changed to allow complaints to be filed with the Tennessee Public Utilities Commission if there was a violation of the Tennessee 811 Act. As it was originally written, when there's a first violation, one of the things that the enforcement board that does the enforcement, one of the things that they could do is, rather than impose a civil penalty, they could just require training. And generally, that's what they did. So the law was changed, sort of now requires that even on a first offense, that a civil penalty be imposed, but did authorize the investigator for TUPUC that's investigating the complaint to make an offer for training only. So sort of just says the enforcement board itself has to impose a civil penalty, but it gives the investigator the ability to try to work out a settlement of training only with the person against whom the complaint was filed. So the last thing that was changed is, the way that this program was set up, civil penalties were placed into a separate fund so that it didn't go into the general fund of the state. And really it was limited to be used for educational purposes related to underground utilities and some nebulous ability to give grants to encourage people to join Tennessee 811. Well, those funds have not been used very much. And so TPUC basically wanted the law to change to allow any civil penalties that go into that fund to be used to offset the cost of their civil penalty program. Because the way that the administration of that program is paid for now is when you all get your annual bill from Tennessee 811, whether you realize it or not, there's a little line item in there that imposes the cost of that program for the past year on you all. So ultimately, the hope is an administrative program, which is now being financed completely by you all, can be reduced by using the civil penalties for that purpose. Probably a good idea. I'm going to run through this one real quick, but it's just important because it shows how legislation sort of works. Last year, 2023, there was a bill that was introduced, and it dealt with an entity called the Duck River Agency is the short name for it. And the Duck River Agency had been given some powers by the legislature to sort of look at economic development, but also water supply within the upper Duck River watershed. Historically, that agency was financed by agreements they had with 7 utilities where they paid 5 cents per 1,000 gallons to this agency. They did studies, they did other things, and those were long-term contracts that expired a couple of years ago. And so this agency was going to have to come up with another way to finance themselves. In 2023, a bill was introduced to basically mandate that if you were a public water system and you withdrew water from the upper Duck River watershed, I'm going to explain what that is, but those of the here, they know who you are. There was going to be a mandatory withdrawal fee based upon what was withdrawn. TAUD got involved and said that is a really, really bad precedent for the state. So basically, they came back this year, amended their statute, and removed the mandatory water withdrawal process, and basically put in its place that if you were a member of the Duck River Agency and you were a public water system, then imposing a membership fee that would be established by the board of the Duck River Agency to continue to finance that agency. A lot better than a mandatory water withdrawal fee. It also, the Duck River Agency, their board is actually made up of public officials in the cities and counties in the upper Duck River watershed, meaning their board members are not utility people. It's the county mayor, and it's also the city mayor within the counties where they operate. So historically, the agency had set up a committee called the Duck River Agency Technical Advisory Committee, and they were to sort of approve any kind of projects that were financed by the agency. So this legislation basically made those members, which are the utilities themselves, board members of the Duck River Agency, so they would have some kind of say in this fee that's charged. They also had a weighted system for voting based upon how much water is withdrawn. So most of you all that doesn't affect, it's up here to say, this is the kind of stuff that goes on, okay? And, sometimes you have to take something that's not good and do the best you can to work with it. So this bill was introduced, and this bill requires the following. Every political subdivision, that's you all in here, whether you're a city, county, utility district, must sign a written attestation with the audit certifying that it has not sought or received grants to intentionally pursue a policy described in Agenda 21 adopted by the UN in 1992, the 2030 Agenda for Sustainable Development, UN Summit 2015, the UN proposal to reach zero emissions by 2050, or any other international law or plan that contravenes the U.S. or state constitution. All I can say is duh. Okay? But you're going to be asked to sign a certification moving forward that's going to be in your audit where you're certifying to this. Okay? Those top 3 things, as you could probably tell, probably deal with climate change goals, etc. This last one, I don't know what it means. Another international law or plan that contravenes U.S. or state constitution. I have a hard time believing that a county, a city, or utility district is going to intentionally pursue a grant to do number 4. Okay. So I really don't want you to call me about this because I don't want to have to look up what Agenda 21 was and the 2030 Agenda for Sustainable Development or the UN proposal to reach zero emissions by 2050. I didn't make up this language. That's exactly what it's in the statute. So I'm just bringing it to your attention so that you're not shocked when your auditor puts down in front of you, you have to sign this before your audit can be submitted to the state, because you're going to be asked that. Okay, I need to finish up real quick. Ross talked about his favorite subject, depreciation. And really, because of the ARP money, depreciation got talked about from the utility perspective quite a bit in some of the committees this year. And there was a bill that was introduced that looked like it was doing something, but I'm not really sure it makes much of a difference. So basically, what the bill says is that the comptroller may not consider the annual depreciation of assets acquired within 12 months preceding the audit in determining whether the utility is financially distressed. The way I read that is, your audit, is done through June 30, 2024. So that if you have put in capital improvements that you would start depreciating after that, you basically get a 1-year pass for recording the depreciation. I think that's what this means. So, but it's dependent, that treatment, is treatment by the comptroller for determining whether you're financially distressed. So the capital improvement or the assets depreciation still has to be calculated and put on your books as normal. And to sort of get this special 1-year treatment, the governing body of the utility has to vote to say, we want this treatment. Sounds like it may do a lot. I'm not sure that anybody will even do it because they're going to have to adopt something that says this is the way we want to take advantage of this 1-year, I'm going to say, non-consideration of depreciation for determining whether you're financially distressed or not. If you're making money, this ain't worth the effort. I doubt seriously this one's ever going to happen, but it may. There was a bill that was introduced that basically authorizes the creation of what the statute calls an infrastructure development district, not to be confused with the planning development districts, but this is something new, as an alternative way to fund capital improvements by levying a special assessment on all property owners within a certain territory. So this infrastructure development district is created by a person or persons filing a petition with the governing body of a city to create the infrastructure development district. And the assessments that can be levied can be used to finance infrastructure, which means streets, roads, bridges, sidewalks, and water, wastewater, natural gas, electric, telecommunications, stormwater facilities. So the reason I doubt seriously this is going to happen is because, in essence, if you create one of these, you're imposing a new tax on all the property owners to finance the infrastructure improvements. Okay. Only applies within a city, doesn't apply within a county, doesn't apply with utility districts, but it is a potential mechanism for not the city itself, but the city has to respond to a request from persons that are wanting to come up with a different way to finance infrastructure to create one of these infrastructure development districts. Doesn't have to be citywide. They may say, here's the high growth area. We want to create the infrastructure development district in this area. But in the end, if it's done and approved, every property owner is going to wind up getting a special assessment. No, it can be. So, but again, it is something that's done, can't be created within a utility district, can't be created within a county, only within a city. All right, real quickly, always have to deal, somebody's changing compensation in some shape, form, or fashion every year. That's the one for this year. There's a utility district known as the Reelfoot Lake Regional Utility and Planning District, created by a general bill of local application. And they basically got their local legislator to pass a bill to increase their monthly compensation from $200 to $400 and authorizes their commissioners to get medical insurance coverage paid for, just like other utility districts. Why did they have to do that? Because they were created by a special act of the legislature. So the general law does not apply to them. 2 to 3 times a year, I get a call from Greta at Reelfoot Lake Utility Regional Planning District and says, Don, can we? And so every time I send Greta a copy of her statute that says, here's how you were created, and it doesn't say you can do that. Everybody else might be able to do it, but you can't. Okay. I'm going to talk about this one. Every year, and it seems to be more and more, utility authorities are being created. They're generally created, but it's just a legal shell for something that somebody wants to do. 3 of them this year, all of them except the Humboldt Utilities Authority. The Humboldt system will just give their assets over to the authority. And generally, when an authority is created with a city, the authority sort of operates the utilities completely on its own. They can issue bonds on their own. They can own real property on their own. And they don't really need any approval from the governing body in the operation of the utility. So I appreciate your patience. If you want to ask me a question about any of that, come up afterwards. But it's close to 3 o'clock. Let's take 10 minutes, come back in at 3:10. Thank you.